turn of the first quarter of the 21st century, I would like to present the emergence of human trafficking in Europe. At the turn of the first quarter of the 21st century, the world, especially Europe, faced huge migration wave that had never happened before in its history. As a consequence of migration, human trafficking emerged in the continent. Migrant smuggling has developed significantly since the migration crisis began in 2015. The Council of Europe Convention on Action Against Trafficking in Human Beings entered into force on 1 February 2008, following its 10th ratification. While building on existing international instruments, the Convention goes beyond the minimum standards agreed upon in them and strengthens the protection afforded to victims. The Convention is the first international legal instrument to take a human rights-based approach to the fight against human trafficking. The purposes of this convention are to prevent and combat trafficking in human beings while guaranteeing gender equality, to protect the human rights of the victims of trafficking, design a comprehensive framework for the protection and assistance of victims and witnesses while guaranteeing gender equality as well as to ensure effective investigation and prosecution. Also, to promote international cooperation on action against trafficking in human beings. In order to ensure effective implementation of its provisions by the parties, this convention sets up a specific monitoring mechanism. An important added value of the Council of Europe Anti-Trafficking Convention is the monitoring mechanism set up to supervise state parties' compliance with the obligations contained in the Convention. It consists of two pillars: an independent expert body, the Group of Experts on Action Against Trafficking in Human Beings, in short GRETA, which is composed of 15 members who sit in their individual capacity and are selected on the basis of their expertise in the areas covered by the Convention. This committee, the, the Committee of the Parties, which is composed of representatives of the parties to the Convention. GRETA evaluates periodically each state party and draws up evaluation reports. GRETA has to date published over 130 country evaluation reports. The evaluation procedure is divided into rounds. Since 2010, GRETA has conducted 3 evaluation rounds of the Convention, and in July 2023, it launched the 4th evaluation round. While the European Convention on Human Rights does not expressly mention trafficking in human beings, its Article 4 prohibits slavery, servitude, and forced or compulsory labor. In its case law, the European Court of Human Rights has interpreted Article 4 by extending material scope of this provision to include trafficking in human beings. To interpret the concepts contained in Article 4 of the Convention, the Court refers to other international instruments, including the Council of Europe Convention on Action Against Trafficking in Human Beings. GRETA's monitoring of the implementation of the Convention contributes to preventing violations of the European Convention on Human Rights, including Article 4, which prohibits slavery and forced labor and includes within its scope trafficking in human beings. A growing corpus of judgments of the European Court of Human Rights related to different articles of the European Convention on Human Rights refers to GRETA's reports. In Chowdhury and versus Greece, the applicants, 42 Bangladeshi nationals, were recruited in Athens and other parts of Greece between the end of 2012 and early 2013 without a Greek work permit to work at the main strawberry farm in Malolada. Their employers failed to pay the applicants wages and obliged them to work in difficult physical conditions under the supervision of armed guards. The applicants alleged that they had been subjected to forced or compulsory labor. They further submitted that the state was under an obligation to prevent their being subjected to human trafficking, to adopt preventive measures for that purpose, and to punish the employers. The court held that there had been a violation of Article 4 of the Convention, finding that the applicants had not received effective protection from the Greek state. The court noted in particular that the applicant's situation was one of human trafficking and forced labor, and specified that exploitation through labor was one aspect of trafficking in human beings. The court also found that the state had failed in its obligations to prevent the situation of human trafficking, to protect the victims, to conduct an effective investigation into the offenses committed, and to punish those responsible for the trafficking. Uh, there is another case. It is called TV versus Spain. This case concerned a victim of human trafficking from Nigeria to Spain. The applicant alleged that the Spanish authorities had failed to investigate, prosecute, and punish those responsible for subjecting her to human trafficking and sexual exploitation between 2003 and 2007. She had managed to escape her alleged traffickers and brought the criminal complaint in 2011. The court held that there had been a violation of the procedural aspect of Article 4 of the Convention in the present case, finding that the Spanish authorities' investigation had been tainted with shortcomings, and that these shortcomings showed a blatant disregard for the duty to investigate serious allegations of human trafficking, an offense with devastating consequences for its victims. The court noted in particular that no measures had been taken at all in the first 2 years of the investigation, that the investigators had failed to pursue obvious lines of inquiry, and that the decisions to provisionally dismiss her case in 2017 had been superficial and insufficiently reasoned. In his judgment in the case of Krasnova versus Bulgaria, delivered on 28 November 2023, the court found that Article 4 of the European Convention on Human Rights lays down a positive obligation to enable victims of human trafficking to claim compensation from their traffickers in respect of lost earnings. The case concerned the attempts of a female victim of human trafficking to obtain compensation for the earnings from sex work that her trafficker had taken from her. The Bulgarian court had refused compensation, stating she had been engaged in prostitution and returning the earnings from that would be contrary to good morals. In its decision, the court referred to the third-party intervention made by Greta in this case in September 2021, according to which to deny victims of sexual exploitation compensation from their traffickers for loss of earnings, because prostitution is considered illegal, immoral, or undesirable, would run contrary to the object and purpose of the international instruments created to provide effective protection to victims of all forms of human trafficking, in particular Article 15 of the Council of Europe Anti-Trafficking Convention. The court stressed that the possibility for victims to seek compensation in respect of earnings withheld by the traffickers could redress the full extent of the harm suffered by them. It would also give them the financial means to rebuild their lives, and would go some way towards ensuring the traffickers are not able to enjoy the fruits of their offenses, thus reducing the incentives to commit trafficking. Moreover, the court asserted that compensation must be considered an essential part of the integrated state response to human trafficking under Article 4 of the European Convention on Human Rights. Well, the concluding remarks of this virtual article are that Europe needs an effective action plan to prevent human trafficking and to use all the legal instruments to save the victims of human trafficking. Thank you for listening.